Welcome to the deep dive. Today, we're tackling a really fascinating power dynamic within Indian federalism.
Yeah, it's a complex one.
We're plunging into a recent and I think quite significant Indian Supreme Court judgment, INSC 481 of 2025.
That's the one.
It really throws a spotlight on the governor's crucial role in the lawmaking process at the state level.
Specifically, their powers regarding, assent, withholding assent, or reserving bills for the president.
Exactly. It's all about understanding who has the final say, really, and how those checks and balances work.
And this judgment, it gets right to the core of how India's federal structure functions, doesn't it?
Yeah.
Examining that sometimes tense relationship between states and the center.
Mm-hmm.
So for listeners, getting into the details here gives a vital perspective on how state laws actually get made.
And the mechanism designed to keep it all in balance.
Precisely. So our mission in this deep dive, drawing mainly from the court's own words in the judgment,
Which is always the best way.
is to pinpoint the key interpretations, the pronouncements on the governor's authority, and what it all means for that state union interplay.
Okay, let's unpack this. Maybe starting with a bit of history. This whole idea of needing assent for a bill to become law, it didn't just appear overnight, did it?
Oh, absolutely not.
Yeah.
The judgment itself points back to the Government of India Act, 1935, Section 75 specifically,
Right.
as a really important model, a precursor for Article 200 of our Constitution.
Which is central to this whole discussion.
It is. But here's a key early insight the court highlights. Article 200 takes inspiration from Section 75, yes, but it deliberately leaves out the phrase, in his discretion.
Ah, interesting. So that was a conscious choice.
Very much so. Right from the start, the framers were intentionally limiting the governor's independent judgment compared to those earlier models. That tells you something about the intended relationship.
So even before 1947, the thinking was evolving on how this should work. Were there other steps, other milestones mentioned?
Definitely. The judgment touches on earlier ones, the Government of India Act of 1919, for instance.
Okay.
The Commonwealth of India Bill, 1925, even the Nehru Report, they all sort of illustrate this gradual shift in thinking.
About how assent should work in India.
Yes, moving towards the system we have now. The Nehru Report, for example, it didn't actually force the Governor General to assent, even if a bill was sent back and repassed. A bit different.
It's always fascinating hearing about those early debates, the different visions that shaped things, and the Constituent Assembly itself.
Yeah.
They must have had some strong views on the governor's role here.
You bet they did. The judgment references Draft Article 147 and, yeah, lively discussions around the governor's discretionary powers.
Figures like Ambedkar involved.
Absolutely. Dr. B.R. Ambedkar, Shri H.V. Kamath, they had differing perspectives. Some argued for, a stronger discretionary role for the governor, a check on potentially problematic laws.
While others,
Others really emphasized ministerial responsibility. The governor should act on the advice of the elected government, mostly.
makes sense.
And that second proviso to Article 200, the one about bills affecting the High Court's powers, that was a particularly hot topic.
Yeah.
Ambedkar strongly pushed for it, to protect the judiciary.
Okay, so with that historical backdrop, let's get to the nuts and bolts. Article 200 today, a bill lands on the governor's desk. What are the options?
Essentially, Article 200 lays out three main paths. First, the straightforward one, give assent,
Yeah,
bill becomes law.
simple enough.
Second, the governor can withhold assent, though crucially, not for money bills. That's an exception.
Right. And third,
Third, reserve the bill for the president's consideration. Send it upstairs, so to speak.
okay, three options. But that second one, withholding assent, it's not just a flat no, is it? There's more to it.
Exactly right. The first proviso to Article 200 adds a really critical layer. If the governor decides to withhold assent,
Yes.
the Supreme Court interprets this to mean the governor is constitutionally bound to return the bill to the state legislature.
Oh, okay. Not just an option, but an obligation?
An obligation. And as soon as possible. That's the key phrase. They have to send it back with a message, maybe requesting reconsideration, perhaps suggesting amendments.
So it's not a fourth option, but part of withholding assent.
Precisely. It's a mandatory step if assent is withheld initially.
Mm-hmm.
And the judgment really hammers home the importance of as soon as possible. Cites the Telangana case.
Right, the state of Telangana versus the governor.
Yes. To stress this isn't just advice. It's a constitutional imperative for speed. Prompt action is required.
What about this idea of a pocket veto? Can a governor just put a bill in a drawer and forget about it, let it die quietly.
The Supreme Court is very, very clear on this. No, a pocket veto is not permissible for the governor under Article 200
Why not?
because of that as soon as possible requirement. It just rules out sitting on a bill indefinitely without making a decision. The court says that kind of inaction goes against the whole constitutional framework.
That makes sense. Now, you mentioned reserving bills for the president. Is there a situation where the governor has to do that, not just chooses to?
Yes, absolutely. That's covered by the second proviso to Article 200.
Okay.
It mandates that if a bill passed by the state legislature has provisions that, if enacted, would chip away at the powers of the High Court,
Diminish the High Court's powers.
then the governor has no discretion. They must reserve that bill for the president.
So that's the safeguard we talked about earlier, the one Ambedkar argued for.
Exactly. It's there specifically to protect the constitutional position and authority of the high courts.
Right. So, okay, the bill goes up to the president under Article 201. What happens then? What are the president's options?
Under Article 201, once a bill is reserved, the president basically has two main choices.
Which are?
Give assent, the bill becomes law. Or withhold assent, effectively rejecting it.
Okay. And following the pattern, is there a proviso attached to Article 201 as well, like there was for the governor?
There is. The proviso to Article 201 says if the reserve bill isn't a money bill, the president can choose to direct the governor to return it to the state legislature for reconsideration. And there's a time frame within 6 months.
Okay. Send it back down for another look.
Right. And if the state legislature then repasses the bill, maybe with amendments, maybe without it, goes back to the president again for consideration.
And then what happens? Is the president bound to assent, like the governor's supposed to be with a repassed bill under Article 200?
This is where it's interesting. The judgment notes a subtle but potentially significant difference in the wording.
Oh.
The proviso to Article 201 doesn't have that specific phrase, shall not withhold assent therefrom, after the bill is repassed. That phrase is in the first proviso to Article 200 for the governor.
So that missing phrase. What does the court suggest it means? Does the president have more freedom at this stage?
That seems to be the court's interpretation, yes. They suggest the president is understood to have a greater degree of scrutiny over bills reserved under Article 201.
Especially certain kinds of bills.
Yeah, particularly those touching on broader national issues. Things like major economic policy, fundamental rights, or matters relating to, say, national integrity.
The idea being the union's perspective might need more weight there.
That seems to be the reasoning. Balancing the state's legislative will against potentially wider national interests.
Okay, this whole process involves discretion, governor, president. Can these decisions be challenged? Can the courts step in if someone feels this discretion wasn't used properly?
That's a really critical question, and the judgment tackles it head on.
And the answer?
The Supreme Court is firm. No exercise of power under the Constitution is completely beyond judicial review.
No power is absolute.
Exactly. Now, the simple act of giving assent, which usually happens on the advice of ministers, might be harder to challenge.
Because it's usually routine.
Right. But the act of withholding assent or reserving bills by the governor, particularly when it's seen as discretionary, that is subject to judicial scrutiny.
So inaction or disagreement can be reviewed.
Yes. The insight is that while assent might be a formality based on advice, delay, or withholding without constitutional grounds, can absolutely be challenged. It keeps everyone accountable.
Okay, so what are the specific grounds then? When can you challenge the governor's actions under Article 200 in court?
The judgment outlines several possibilities. For instance, a clear violation of that second proviso of the High Court Powers one.
Got it.
Or acting directly against the aid and advice of the Council of Ministers in areas where the governor doesn't have explicit discretion. There are exceptions, but generally they act on advice.
What else?
Unreasonable delay, showing inaction way beyond acceptable time limits. Or if you demonstrate the governor acted on extraneous considerations, things not relevant, or even what the law calls mollified bad faith.
Proper motives.
Exactly. And the court points to landmark cases like Samshir Singh, MP Special Police Establishment, BK Pavitra.
To show how this understanding has evolved.
Precisely. How the view on the governor's discretion and the scope of judicial review has developed over decades.
And what about the president? If the president sits on a reserved bill under Article 201, can that inaction also be reviewed?
Yes. The court clarifies that presidential inaction under Article 201 is also subject to judicial review.
On similar grounds.
Pretty much. Again, the focus would likely be on excessive, unjustified delay or actions that seem fundamentally contrary to constitutional principles.
Are there actual time frames mentioned?
The judgment refers back to suggestions the Supreme Court itself has made previously for governors under Article 200, maybe a month, for assent on advice, perhaps 3 months for withholding against advice.
Hmm.
Rough guidelines.
And for the president?
It mentions a Ministry of Home Affairs memo suggesting an expectation for the president to act expeditiously on reserved bills, maybe aiming for around 3 months for disposal. But these aren't rigid deadlines set in stone by this judgment, more like benchmarks for reasonableness.
Okay, this theory is clear, but let's bring it back to the specific case we started with, INSC 481 of 2025. What actually happened on the ground in Tamil Nadu?
Right, the facts are key. The governor of Tamil Nadu had withheld assent from quite a few bills passed by the state legislature and reserved others for the president.
Leading to the court case.
Yes, the state of Tamil Nadu filed a writ petition in the Supreme Court back in October 2023. Initially, the situation was the governor had withheld assent from 10 specific bills and reserved 2 others.
Okay.
But then, even after those 10 bills were reconsidered and actually repassed by the Tamil Nadu legislature.
They went through the whole process again.
Yes. The governor then reserved these repassed bills for the president's consideration. And importantly, the state argued this was done without seeking or acting on the advice of the Council of Ministers.
Ah, so that seems like the real sticking point. Sending repassed bills to the president without ministerial advice.
That was certainly a core part of the state's argument.
So how did the Supreme Court react to the sequence of events? Withholding, repassing, then reserving the repassed bills?
The court took a very, very firm stance. They specifically called out the governor's significant delay in acting on those 10 bills after they were repassed.
The delay was a major factor.
A major factor.
Yeah.
And they viewed the subsequent reservation of these repassed bills for the president as potentially a way of circumventing the proper constitutional process.
So what do they do?
They invoked their special powers under Article 142 of the Constitution.
Article 142 that allows them to ensure complete justice.
Exactly. It's an extraordinary power. Using it, the court declared that those 10 repassed bills would be deemed to have received assent.
Deemed assented. When?
On the date they were presented back to the governor after being reconsidered by the legislature, which was November 18th, 2023.
Wow. So the court essentially said, okay, these are laws now because of the governor's actions, or rather inaction.
That's the effect, yes. A very decisive move.
What was the core reasoning? Beyond just the delay, why such a strong intervention?
Well, the court went back to fundamentals. It reiterated that the governor is, primarily, a constitutional head, expected to act on the aid and advice of the elected Council of Ministers.
Discretion is the exception, not the rule.
Exactly. Discretionary powers are limited, they have to be explicitly stated, or arise by necessary implication from the Constitution.
And in this case?
In this specific instance, the court clearly felt the governor's actions, especially reserving repassed bills, apparently without ministerial advice, and after that long delay, just didn't align with the spirit of the Constitution.
Or the democratic will.
Or the democratic will expressed by the state legislature. The court felt this prolonged inaction was effectively stalling the whole legislative process, undermining the legislature.
So Article 142 was seen as necessary to fix that blockage.
It seems so. In what they saw as an extraordinary situation, they used that power to ensure the constitutional machinery wasn't, indefinitely jammed.
It's always useful to see how things compare internationally. Did the judgment look at practices elsewhere regarding assent?
Yes, it did, briefly. To provide some broader context.
Where did they look?
They mentioned the UK, Canada, the US, New Zealand, Singapore. Just a quick tour.
Any key differences or similarities?
Well, in the UK, royal assent is now pretty much a formality. Canada views the Governor-General's assent as part of the legislative act itself, generally not something for the courts to review.
And the U.S.
The U.S. has the president's assent, of course, and that specific concept of the pocket veto, but under quite defined conditions. New Zealand and Singapore have systems with more structured presidential discretion, sometimes with actual time limits.
So a mix of approaches.
Yes, it just helps highlight what's unique about the Indian model and where there are common threads in how democracies handle this final step in lawmaking.
Okay, so let's try and wrap this up. Bringing everything together from this deep dive, what are the absolute key takeaways from this judgment? What should listeners really hold on to?
I think there are several vital points. First, The judgment strongly reinforces the governor's duty to act within the constitutional rules and, crucially, with reasonable speed. No undue delays with state legislation.
Expedition is key.
Yes. Second, it clarifies that link between withholding assent and the mandatory step of returning the bill for reconsideration. You can't just withhold and do nothing.
Right.
Third, it really underscores that the governor's discretionary powers are meant to be limited. They aren't supposed to be a parallel authority to the elected government.
And fourth.
And fourth, it firmly establishes judicial review over actions under Articles 200 and 201, especially where there's excessive delay or actions that seem to undermine constitutional principles.
So a clear message about the governor's constitutional role.
A very clear and important message, yes, about responsibilities in the state legislative process.
This has definitely been a valuable shortcut to understanding what seems like a really complex but critical legal development. So for you, the listener, as you think about this, consider the implications. That balance of power between the union and the states in India.
It's a constant dynamic.
And the governor's role in upholding constitutional democracy within that federal structure. What does it truly mean? What other questions does this judgment spark for you about how Indian federalism actually works on the ground?
Maybe it encourages digging deeper into the full judgment or finding other discussions.
Absolutely. Food for thought. Thanks for joining us on the Deep Dive.